Welcome to All Things Financial with Jack Driscoll.
Welcome back again, everyone, to another edition of All Things Financial. We appreciate you all tuning in and viewing. For those of you seeing it on TV, please remember you can get a copy of a lot of our recordings if you get your email address to us. We'll send you out any of them that you'd like to see or hear on email. Today, we have a guest back with us, Matt Carl. Appreciate your coming back again, Matt.
Oh, thank you.
And if you can refresh everyone a little bit about what firm you're with and a little bit about yourself and type of practice you have.
Well, Jack, I've been a practicing attorney since 1982, representing individuals and businesses in their transactional and their personal needs. I'm with the firm of Blumling and Gusky. We're located downtown in the Coppers building. But I get out to visit my clients and get to know them better too. But I appreciate you having me on the show.
Oh, absolutely. What we did last week, for any of you who missed it, you can tune into last week's show. We began a discussion on estate planning, general estate planning, and the lack of estate planning in so many cases that we run into. And what Matt and I want to talk to you about today is further that conversation with different areas regarding estate planning. Some of those deal with trusts, some of those deal with wills. So what are you finding are some of the most major questions people are running into today or confused about trusts versus wills and things like that that might come up?
Well, you know, Jack, the big question recently has been, okay, well, I want to avoid probate. I don't want to have a will because I've heard probate is expensive and it takes a lot of time and things of that nature. And you'll take a look at some, newspapers, some magazines, and there'll be an ad. Let's put together what is referred to as a living trust.
Okay.
And so I have some clients that approach me and say, gee, we don't want a will, we want a living trust. And before I just say, okay, this is what I'll do for you, because we can do living trusts. I explain to them really what the difference is between the two and really whether or not it makes any sense to pick one over the other. Mm-hmm. Generally, my advice is go with the will, and I'll be happy to tell you why.
Okay.
Yeah, the living trust is a trust where an individual, let's say like myself, decides that I want to take my assets and put it in my name as a trustee for myself, okay, which sounds a little bit silly, mm-hmm. Okay, but it says as a trustee, I'm able to do whatever I could do with the assets as if I owned them myself, but in the event I become incapacitated or in the event that I die, mm-hmm. that there is a successor trustee or another person who's capacitated or somebody who will be able to handle my assets and administer them, will handle them either on my behalf during my lifetime until I pass away, and then pass it on to whomever I designate under the living trust when I'm gone. And the whole idea behind these living trusts is that you're front-loading the transfer of assets, okay?
Okay.
Instead of having the transfers occur after your death. That's why they say it's a probate avoidance tool. And does it work? Yeah, it works. But here are the caveats. First of all, the probate estate, one that goes whether you have a will or you don't have a will, you go through the courts. The court has an executor appointed. That executor distributes the asset after paying off all your debts and all your taxes and so forth, and goes and then distributes to your beneficiaries. In that process, you file an inheritance tax return here in Pennsylvania.
Okay.
That's required whether you go through probate or you don't go through probate.
Okay.
So the living will really provides you no benefit from inheritance taxes. There's other trusts that you can avoid inheritance tax with, but they don't involve quite the freedom of handling the assets that you do. Mm-hmm. The second thing is, the probate process does cost money, because you are involved in doing things that are transferring assets, like preparing deeds, preparing bills of sales, changing bank account titles, and things of that nature. But in the living will status, those transactions take place while you're alive. You have to do them yourself. Okay? So all you're doing is you're front-loading the transfer.
Oh, you mean the living trust?
Yes.
Yeah.
Yeah, on the living trust, let's say, for instance, you set up a living trust. You're going to be changing the name of your name off of your deed to your house, not as yourself as an individual, and conveying it to yourself as a trustee in order to get it into the trust.
I see.
Okay, so you're paying the same filing fees for filing the deed. Now, in Pennsylvania, there's no transfer tax if your trust is set up appropriately.
Okay.
So that's not an issue, nor is it an issue if you pass it under a will. Okay, there's no transfer tax there either. So far we're having kind of a balance match between here. All you're doing is saying, okay, well, during my lifetime, I'm going to transfer the assets into the trust instead of outward. But then you get it into the trust, okay? And let's say your children are the beneficiary of that trust. Then your successor trustee, after you pass away, has to transfer that again. Okay, so now you're adding an additional transfer onto the whole deal.
Okay.
Again, no transfer tax on that, but you're not voiding inheritance tax either. The biggest problem, okay, that I have seen in the administration, and the administration, of course, is what we do after you pass away of these living trusts, is that the people who get gung-ho about them, okay? And I've seen this. They get very gung-ho about them, and they set it up, and they transfer all of their assets into it. They follow the instructions. Typically, it's in a big book, with the instructions and so forth. And then they set it aside. And the only time they really change it is in the back of the book. It has a beneficiary designation form, and
a special personal items.
Yeah, things like that. I have one quick funny story. My dad called me up one time, and he said that his friend came to work and told him that he went over and he visited his mom, who had one of these living wills. And he looked in the back, and he saw that what used to be 50-50 between him and his sister was scratched out, and it was 75% and 25% to him.
In the living trust?
In the living trust. So in the living trust, when he saw that, he came to my dad, and of course my dad asked me if that was legal, and I said, well, Dad, either under a will or a trust, children, you don't have to give anything to your children. It's a perception that most people want to treat their kids equally, but you don't have to treat your kids equally. And so he says, well, what can he do? And I told him he should visit his mother more often. So I don't know if he went back up to 50%.
You have to earn your way back up.
Yeah, but getting back to my last point on the living trust is that they're so gung-ho and they get all that stuff done.
Yeah.
Okay? Well, then, they go out and they buy a new car. Okay, that car's in their name. Or let's say they go out and they get excited and they start a new brokerage account and they forget to put it in their name as in trust and things of that nature. Here's the double poison. Not only are you administering under a trust, but now you have to take those assets that you forgot to put into the trust and go through probate to get rid of those.
Yeah.
So it's generally I recommend against it. The only time I do recommend it is if people want, for some private reasons, not to have their will in the county records. If they want to do something that way, well, then we do use trust. Not necessarily a living trust, though, but we do use some trust for that purpose.
Okay. Do you run into other areas where you find yourself guided toward needing different types of trusts for different types of circumstances?
Oh, sure. There's a, probably what most people have is if you have a disabled child or an adult child with special needs that might be receiving some benefits from the government, then you should certainly, and I know people in these groups know this very much because it's general knowledge, through societies that help provide care and support for these families, that you would use a special needs trust or some other form of trust, pooled trust, that you can place your money into so that money isn't just used to replace the government benefits that your child might be receiving. Now, there's different kind of programs that are affected differently, but in general, if you have a person with special needs, it could be a spouse, a companion, it could be a child, then you typically should be seeing some type of a estate planning attorney who has some experience with special needs trust to see if you would benefit from one of those. And then you have all other kinds of trusts. There's trusts that we set up for life insurance. We call those irrevocable life insurance trusts, or the way we use acronyms all the time, ILITs. An ILIT is a trust that you set up, primarily to take insurance and put it outside of your estate. This typically involves a little bit more complex estate planning for larger estates, people with business interests and things of that nature. Right now, federal estate tax will not kick in unless you have over $5,400,000 and some $1,000, which is per individual. If you're a married spouse, then you have $10,800,000. And I wish I knew a lot of people who had those things, but it is literally the top 1%ers. So ILITs benefit them very much because insurance that they own and control at the time of their death gets added into that pot, and the federal government can take up to 45% of insurance, which typically is used to pay that tax, but even if you are in a situation where you just want to get insurance for the benefit of a spouse or benefit of your children, you may want to consider placing that insurance in a trust because, as you and I both know, it was a long time ago, 30 years, that the limit on federal estate tax was $600,000.
Yeah.
You buy $1 million insurance policy, all of a sudden you were in federal estate tax land. Right. We can't guarantee where federal estate tax is going to be. I mean, less than a decade ago, it was at $1 million.
Right.
So it may go back down.
Yeah, that's a good point. That wasn't long ago.
It wasn't that long ago. So
Seems like forever.
Yeah, it does seem like forever.
But 2010, I guess it was zero that year or whatever. Remember, or unlimited, I should say.
Well, they were saying some billionaires were actually staying on life support until January 1st, 2010.
Steinbrenner, or who was the New York
I forget who it was.
Died right in the right year with no federal estate tax. But I remember that. That was not that long ago. So these laws can change fast.
Yeah, and as we mentioned in the prior program, when plans were put together back in the 80s and never reviewed, people were using what we typically called AB trusts or unified credit trusts with spousal trusts, because anything that you gave to your spouse under federal estate tax went tax-free and would only be taxed upon their death. So you tried to maximize using the unified credit, which back then was $600,000. So the balance of what was in your estate would go to your spouse, and then that would pass tax-free. So there was really no burden on the spouse at that time. Now, people who still have these wills, they still work, but they don't. And here's why. They work in that it passes the assets when you pass away, but right now, if you don't have $5 million worth of assets, all of the first amount of the money, let's say it's just $1 million, goes into a trust that you really don't need, because it says it fills up that unified credit trust first,
Right.
which means your spouse now will have to deal with the trustee to get her money or his money, and therefore, if you have those types of trusts, you should really have someone take a look at it and revisit your financial situation and determine, do we really need that kind of trust anymore?
Yeah, and I've run into that where the attorney had unraveled the AB trust prior to death of the first spouse, thank goodness. But this situation was about a $2 million estate, so we had $1 million A trust, and you know how they worked, where the one spouse, whoever died first, had $1 million allocated to them, and the other $1 million was allocated to the second spouse, let's say. We didn't know who was going to die first. And then the one who died first, the living spouse would inherit what they could without the federal estate tax, and the rest would go into this trapped trust that wasn't directly given to the spouse. And like you said, they had to deal with the trustee and the limitations and the shackles. And the only reason they went through all this exercise was to beat the federal estate tax. But here the federal estate tax law had already changed, and they could have had up to $5 million go straight to the spouse without any of those shackles. And you're right, it was awkward.
Yeah, it's cumbersome, yes, dealing with a trust when you don't need one.
Yes.
So
yes.
if you do have a will that was prior to 2000, I would highly suggest that you pull it out and have somebody take a quick look at it to make sure you don't fall into that scenario.
Yeah. The other thing is, even though we do the wills or have the attorneys do the wills and the trusts and things like that, I, being a financial planner, I'm not an attorney. I have other areas that I have to look at which fall outside of the area of the wills and the trusts, like IRA beneficiaries and 401k beneficiaries and annuity beneficiaries and things like that. So can you talk a little bit about that? Because sometimes people will say, I changed my will so I don't have to worry about anything else. I have all the right kids' names on there, things like that.
Oh yeah, it's not just, accounts where you can designate beneficiaries. It's also your insurance, who your primary and secondary beneficiaries are. They should regularly be looked at. And again, you're not the lawyer, I'm not the financial planner. I highly recommend that you take a look, particularly on IRAs, what the financial consequences are of naming children as beneficiaries as IRAs, or naming an estate as a beneficiary of an IRA, because they all have income tax outcomes that may not be the ones that you want. We call those non-probate assets because they operate by law. By operation of law, they go to the person named as the beneficiary on the designation. And typically, if you don't name a beneficiary, the company will tell you where that money is going to go. Yeah. So that's good advice there, Jack.
And then the other thing is, we run into a situation where we think we have everything all figured out, and the CPA comes in and says, well, wait a minute. There are different types of assets and different tax consequences. If you direct these particular assets to your children, or one child, let's say, who's in a low-income situation, and this other type of asset to this other child, it's still a 50-50 split. But by directing which type of assets go, there's a tax advantage maybe for the benefit of the kids keeping more of your money, not only for federal estate tax or probate, but also income tax and things like that. So that's why I said at the end of last show, and I'll say it again, I think the key is for every family and business owner and everybody who's involved to surround themselves, again, with a professional team of a certified public accountant, a well-qualified estate planning attorney, a well-qualified certified financial planner, assembling them with your team, helping you make much better decisions and keeping more of your money going from you to the next generation or your spouse or charities or wherever you want it to go in the most efficient manner.
Yeah, that's absolutely correct, Jack, because one of the first things I will do when I meet with a client is I'll ask them, who is your accountant? Who is your financial planner? Because they have information that I need to help do my legal job best. And I will have to share my information on what you want to do with your estates and with your businesses so they know what to do best for you financially and on an accountant basis.
Yeah, we run into this now. Is there any way people can get on? Do you have any newsletter that you put out or anything like that, or a way people can contact you or get more information in this type area?
Yeah, I show up on your show.
Well, that's one way. That's a good way.
Well, I'm kind of an old guy. No, I don't do a lot of internet broadcasting or anything. We do have a website at bloomlinggusky.com where there's more information about myself and my partners and the associates in the firm and the type of work that we do.
Okay, very good. Yeah, appreciate that. Well, folks, I appreciate everyone tuning in to another edition of All Things Financial. We're dealing with many areas here, and you've known that from the other shows. Matt Carl was nice enough to come on as a guest here. We've covered 2 shows on estate planning, and I hope some of this information is helping prompt you listeners and you viewers to recognize, hey, we've waited. We keep saying we're going to do this someday. Now should be that day. We don't want to wait forever. Maybe it's time we get this taken care of. It's rather simple, isn't it, if they actually want to do that?
Yeah. I mean, give me a call, 412-227-2500. I'll be happy to help you out or tell you that you're in good shape.
Very good. Matt, appreciate your coming on the show again. Everyone listening and viewing, thank you very much for tuning in. We'll be back again next week with another edition of All Things Financial.
You've been listening to All Things Financial with your friend with the answers to all financial matters, Jack Driscoll of Driscoll Insurance and Financial Services. Securities and investment advisory services offered through Sage Point Financial Incorporated, a registered broker-dealer and registered investment advisor and member FINRA and SIPC. Driscoll Insurance and Financial Services is not affiliated with Sage Point Financial, Inc. or registered as a broker, dealer, or investment advisor. You can reach Driscoll Insurance and Financial Services Incorporated at 412-833-1500, and they are located at 2738 South Park Road, Bethel Park, Pennsylvania, 15102.